Good morning, everyone. Thank you so much for joining me today. I know it's a cold day, so I'm very grateful that you are here listening with me this morning. So today we're going to talk about the best practices in preventing and managing litigation for small or growing businesses. If you have questions at any time, you can certainly put them in and we'll take them as we go. Also, if you have any interest in downloading the slides, you can do that as well. If you have any problems doing so, feel free to email us. You'll have the email address in the same invitation that you received. So feel free to do that anytime, but let's dive right in, okay? So today we're gonna cover this in a bit more of a digestible manner and get into 10 tips on using the law to proactively mitigate your risks. As it says, you know, disputes are inevitable, but litigation certainly is not. To tell you a little bit about me, I'm a new associate here at Kelli Santini. I've been with the firm since 2015, but I was called in 2018. And I focus mainly on employment law, insurance defense, and civil litigation. So I spend most of my time trying to make sure to keep our clients out of court where necessary, and only to actually attend court if we absolutely have to, and in very specific contents. So that is a little bit of my background here today. For yourselves, if you're a small business owner, you're no stranger to having to set goals for your business and mapping out plans to achieve those goals. But there's one thing that nobody wants to plan on, and it's having the disputes and the disputes that blow up. Some of those things can really be dealt with ahead of time and avoided altogether, and that's what we're going to focus on today. You know, whether it's a disagreement with a customer to a lawsuit with a competitor, a business dispute takes focus away from where it should be, running your business successfully and getting on to bigger and better things. If they go unmanaged, the disputes can and do become litigation. And that's certainly something that no one needs to have to deal with if they can avoid it. So while we appreciate that all businesses recognize the importance of limiting risk, many neglect to actually ensure they're effectively using the law to limit that risk in a pragmatic way. So here at Kelli Santini, we represent clients from all forms of businesses. We routinely advise clients on ways to avoid litigation, not simply how to commence it. And as a litigator, I can tell you, really, it takes up such valuable time to go into litigation and so much energy and so much funds that, again, you want to do everything you can to avoid having to be in a claim and to be able to responsibly shut down claims early and often. And often, you know, with that cost, when you're thinking about the cost of litigation, it's always higher than what you'd expect, not just in terms of legal fees, but the time, the stress, the lost business productivity, the lost opportunities, and the sheer frustration of having to deal with something like this on an ongoing way. So today, let's talk about the 10 key ways to actively manage those legal risks and secure your dispute's best possible outcome at the earliest possible point. So before we get into the tip, I just want to make sure that we're all clear what the litigation process actually involves. You know, we need to understand what we're actually trying to avoid. Court. Litigation is the process of taking a case to court. It's usually connected to civil lawsuits, meaning just where one person is suing another, and it involves at least the following things you see on your screen. We spend a lot of time in number one, in that pre-litigation investigation, writing demand letters back and forth to try and actively negotiate. Again, this both builds the case if we need to go to litigation, and ideally prevents the case from going forward, where we can clarify the legal issue, manage a dispute that's happening, and avoid actually having to go through each one of these steps. Each one of these steps takes time. Each one of these steps can be extended. Each one of these steps is documents and evidence and adjournments and back and forth. Because they are that complicated, it takes years. Typically, we see cases going for years and years before they're getting resolution. And in that time, your business is ongoing. So you have this hanging over you each and every time. So throughout that entire 12-step process, you'll have to pay for court charges as well as fees, expert witnesses, and your lawyers. And even if you win, one of the biggest issues people don't see coming is actually whether you've got a judgment or not, enforcing that can be an entirely separate matter. To be able to actually collect money that you win, you're going to have to make sure the person or business that you're suing has money that you can get, has assets that can actually be seized or sold, or has a debt owed to them by someone else. Maybe they have a bank account where you know the bank holder is. Maybe they have employment income that can be garnished, but it becomes difficult if they are self-employed, they're doing this themselves and you're not sure who their clients are, or things aren't kept in their own names. So enforcement is often something that people don't realize. They get caught up in the principles of the argument and not thinking about what that next step happens. So really all it comes down to is this: litigation should be avoided at all costs as a last resort, and only in very particular times is it worth actually taking that step to do so. However, that doesn't mean you can't fiercely advocate for your rights, but there's other mediums and ways of doing that without going right to court. And that's what we're going to talk about today. So undoubtedly the first step to limiting your risks is prevention. Some of it, you know, you're already doing right now. You've already carved out time from your very busy day, over a lunch hour no less, to be here with me talking about things that you can do to proactively manage this. You're already making that decision to limit that risk in a really real way and engage in real time to do so. So you should be commended for already having to spend time with me this morning. And you know, further that, you're in the driver's seat. This isn't something that you have to be totally dependent on a lawyer to do. You know, certain decisions you can make will minimize that onset of litigation, or at least make it less costly if you have to go through. You can minimize your issues that you're dealing with as you go. You know, one of the best things you can do to minimize your legal risks is something you're probably already doing: providing exceptional service and an excellent product. Happier business partners and vendors and customers, they rarely sue companies. When you offer exceptional goods and services, they'll be willing to come and try and resolve some form of issue with you that may emerge as the company is growing. You should know that your vendors and customers are also having an expectation set for them when you come in the door. And if you set that expectation as high and responsive, they will deal with problems with you in a high and responsive way, expecting that same response. So the fact that you value resolving issues comes across, and if you don't, that comes across too. But one of the things you can do is choose to value resolving those issues early and directly in a calm manner, and never a knee-jerk reaction. Those are how the cases get particularly litigious. Some other decisions, you know, that might come into play is making sure you're managing the risk in a proactive way by knowing what you don't know, knowing what help you need, knowing when to engage other experts. Sometimes that becomes, you know, it's a corporate lawyer, sometimes it's an insurance adjuster, sometimes it's going to be a tax planner. Knowing the fact that you have an expertise in your area and bringing in the support that you need in other areas is a key step to prevention. But some things, no matter how much you're preventing, you may need a heads up about. So that takes us to our 10 tips today. So let's turn to tip number 10, setting yourself up for success. One thing that we see, you know, in frankly alarming rates is how many business and small business owners don't actually utilize the best business structure for their operations. Starting a new business is certainly hard enough, but we routinely see that the biggest mistakes startups make is not consulting a legal professional to determine their legal structure from the outset, or as their business expands. The consequences of that can be substantial, including higher taxes, significant personal liability. That is where having good legal advice comes into play. Things you might want to consider that we often see overlooked. You know, and again, coming back to it, is what worked at one point may not work as you expand or bring in partners or things like that. So turning your mind to your structure as your business changes and develops over time is critical. One thing to really know is incorporation is not just for big businesses. Small one-person businesses or family-run, long-standing family-run businesses often make the mistake of thinking they don't need to form a corporation. What worked before worked now. I've started this up. It's been going okay. I don't need to worry about it. But they're not. Often the flip side of that is, even if they are worried about it, they're worried about whether they should do it federally or provincially, or the cost of actually getting those details all done, actually meeting with a lawyer, getting the incorporation documents done, or some will do it themselves and not necessarily realize some of the steps involved. No one is saying you need a lawyer for absolutely everything, but before you submit an application, it's usually a good idea to have it vetted so someone who knows your business is taking the time to talk to you about what this is, the implications that you're about to submit, and what's going on. But I want to make sure you're at least aware of some basic key benefits of incorporating, even if you are a one-person shop. Think about the limited personal liability. Without being incorporated, people can get to your own assets, your own money, your own wealth. On corporations being a totally separate legal entity, that limits your personal liability if you incorporate. Incorporation also gives you things like name protection. It allows the company to continue even in the event of your death. There's continuous existence. You can get increased access to capital. There's multiple tax advantages. And then again, subsidiaries. If you're starting to get bigger and you want to protect your main corporation from potential claims also, you can break off sections as well into subsidiaries for specific operations. Having those multiple entities helps avoid liability for the main company and the shareholders or members of that main company. So as you expand, you might be surprised how early you want to consider subsidiaries. You don't need to be a big business at that point, but there may be parts of your operations you want to parse out. Going to shareholder agreements. This one we litigate a lot, unfortunately. We strongly recommend that there's always a shareholder agreement drafted, negotiated, where people have independent legal advice to come into. And again, you can do these for surprisingly cheap, and people don't realize that. But whether you're in a startup or a small or large business or a family-owned business, all of you can benefit from a shareholder agreement if there's more than you there. A shareholders agreement is just a basic written document, but it helps define the relationship, the rights and obligations between the shareholders and the company, and documents really the expectation of how the company is going to be managed, operated, financed, and even the transfer of shares. It addresses basically the contentious issues before problems arise, and I can't stress how key that is. Doing this before problems arise, where your relationship is good and everybody wants to get into business together, means you can reasonably negotiate and talk about things like what happens if someone wants to leave, what happens if you need to have a dissolution of the business. You talk about it because there's no breakdown of the relationship yet. Everyone's coming together, everyone's invested in creating something here. Doing that once the relationship's tanked, when the relationship is breaking, is a highly litigious affair. If the shareholders agreement hasn't contemplated what happens at business dissolution, that is a highly litigious affair. So doing this early while things are good is just good business practice and good business sense, particularly in family or spousal relationships. You know, you need to think about the things nobody wants to think about because your business is separate. What happens if the marriage ends and you both want to walk away? How is this going to be dealt with? Some of these things people consider are personal, but the reality is when you're running a business, they're also professional. So turning your mind to them when you're still in a place where you're comfortable dealing with each other and working together is crucial to avoiding any issues down the line. It's clear, it's said, everyone knows what happens, everyone felt fairly treated. So can't recommend them enough. And then also consider trademarks. Often I hear small businesses saying, oh yeah, you know, I'll get to that. Make a point of getting to that. Take a little check-in about your legal hygiene. You'll hear me talk about that throughout today. If you're a one-man show or you're talking to a lawyer about trademarking your business, just keep in mind that most businesses, you're going to spend thousands developing your brand, whether it's your Instagram page, your social media accounts, your actual physical logo, all of your business cards, etc. You are branding something of the baby you are developing for the world that you are bringing out to that. To not protect your intellectual property exposes you to risks unnecessarily. And you can think about trademarking, not just your logo and your name. I'm a big fan of pragmatic approaches to lawyers. I don't like to pay lawyers unless I absolutely need to, and I certainly like to group things at the same billable hour so I'm not being overly charged. Think about trademarking your trade secrets, other confidential or proprietary information that your business depends on at the same time. This is where a seasoned corporate lawyer comes into play. So when you're thinking about structure or agreements or trademarks, this is a corporate lawyer kind of question. I'm a litigator, so I certainly am not doing these ones, but these are, I recommend to my clients all the time. This is something that you need to think about and turn your mind to avoid this being an issue down the line. Once you've done it, you have those protections in place and you are avoiding that liability that can come up later by having something to frankly say, point final, this is the last ending response. I'm trademarked, here's my agreement, they're enforceable, we've done it right. So let's get into evidence. If you do have to go to litigation, one of the things that we deal with is evidence. Our evidence, it starts with you. And it starts with you maintaining proper records. I can use, when I have clients who have great proper records and have done their record keeping correctly, it can shut down a claim instantly. I can prove those allegations wrong by sending, this is the document, no. This is the record of that conversation, no. If you are establishing good business practice, take the time to make sure it's written down. One of the things I see, the common mistakes I see, is having a lot of phone conversations or in-person meetings without a follow-up document. Put those in an employment file. Put those on some sort of document somewhere that it's well kept. Make sure you have documents to capture those key strategic decisions you're making and how those developments of those conversations go. You know, we think always about up-to-date financial records, or I can pull up my emails on my servers. But we forget about the things that happen where most agreements happen in person, in the hallway, when that employee came to talk to me about this, when that vendor came to tell me about that. Document these. Please, please, please put dates on them with the year. It doesn't take long. Scribble it. You know, if you want to do it digitally, I'm fine with that too. Just make sure you have some sort of, so-and-so came to see me, this is what we said. It doesn't have to be long and detailed, but having concurrent notes and shows me a process. If you do it from the beginning, which often people are already doing, they're just not storing them effectively to pull it up when they need it. So think about your filing management. Think about making sure that you have a record of key strategic things. If your radar is going off, write it down. If you address something and you felt good about it, I've de-escalated that motion, write it down. Those pieces, lawyers, we love documents, but I love them to avoid going to court. It's so much easier to respond to a particularly litigious matter when I say, listen, I appreciate what you're saying, but I can show you this, this, and this to de-escalate everyone and say, let's talk about what's really going on here and focus that discussion. One of the big things I want to remind you of is please don't rely on text messaging as documentation. Depending on what medium you're using, those records are only kept so long by the telecoms. You need to consider that you may not have access to those down the line. Something could happen to your phone, etc. So text messaging is not a reliable form of documentation. We certainly use it in litigation, and litigators everywhere will tell you it's great when people send you things in text. But the reality is, if you're going to protect your business, you want to do it in a more reliable method. Aim to use email, aim to have documents, okay? Do not forget about social media either when you're talking about records. You got to think about things of, do you have a terms of use for your company website? You know, on the affiliated social media context, if you're taking anybody's personal confidential information, you need to have a privacy policy as well. It's those things that are just basic copyright. Are you taking an image that you found off Google Images and using it on your website or on your Instagram? You need to be cognizant that as social media increases, copyright is becoming an increasingly litigious area. If you're getting into reviews where someone's responding with a bad review and you want to address it, there are rules about how you can and cannot do so. You want to make sure that you're aware of what would qualify as defamation and what someone's simply allowing to be upset with a product or service they've received. If you're not sure, this is where you need to have people you can call to run this by before you respond as a knee-jerk reaction. Moving on to tip number 8, proper insurance helps a lot of this stuff. You know, we see countless instances when litigation starts simply because a particular issue was not covered by insurance, much and often to that person's surprise. It can be absolutely disastrous for companies and employees when a business is pulled into those issues and is suddenly finding themselves responsible for costs they just didn't see coming. So your small business or your growing business should be properly insured against all specific risks prevalent to your line of trade. From there, to assess that, have a conversation with a good insurance broker Insurance agents are there to help you figure out what kind of protection you need. They also have professional insurance to make sure that they're doing so correctly. And they're looking to help protect you against all possible risks. Keep in mind that when you're sued for those things, if it's a covered loss, insurance companies will then take up that legal action, even if it's frivolous against you, which means they're paying for the cost, they're paying for the bills, they're taking those 12 steps to town. You are not. And that becomes really a crucial aspect of a cost saving right there. That's litigation you don't even need to be really a part of. You might have to go and give some evidence, but it becomes someone else's managing and financing that case. Things that you want to consider, different types of insurance. Common things you want to look at is commercial general liability. Depending on what you do, professional errors and omissions. Certainly lawyers or insurance brokers would have that. Insurance for your directors and your officers, and basic life and disability. One thing we often see that people haven't contemplated, particularly if your small business has been around for a while, is business interruption. It's all well and good that you're insured for fire loss during that renovation, but what happens if while that's going on, while that investigation is happening, while they're rebuilding, you actually are not able to run your business or lease to tenants who lived upstairs? You need to think about those particular facts. If you haven't, this is a good time to call an insurance broker and say, like, I just want to touch base. Is this something that I should be having? Obviously, no one's planning for those issues to come. That's why it's insurance just in case. But business interruption can be a shock to people when they don't realize just because the fire's gone, they're not actually getting any money for the income that they're also having lost at that time. They're insured for the fire, but not the business interruption. So take a look at that. Finally, for that one, just make sure you check back in too. As your business changes or you move centers or you brought someone else in, your business needs might change. And you may not realize that because it might have been something as simple as suddenly you brought your husband into your business, or you brought, your son or daughter has now come in and you've decided that they're going to be part of it and they're bringing in a new aspect of the business that you just haven't considered. Don't assume the insurance you always had is enough. Make sure that you're consulting semi-regularly with your broker to make sure you're covered. So now the part that lawyers will harp on the most, tip number 7, make a plan, formalize written contracts. Everyone your business depends on should have a written and legally vetted contract. Please, please, please keep a copy of the executed documents in your records. Cannot tell you how many times I get someone telling me, here's a non-compete, here's something that I've sent. It's not signed. It's not dated. It wasn't brought in because there wasn't proper consideration being brought in. So it's not even enforceable. Even if it's a beautifully written, legally vetted contract, it wasn't handled and implemented in a legally viable way. This becomes really crucial to think of too when you're dealing with longtime vendors. He's my brother-in-law. I know I'm not going to get him on a contract. Put him on a contract. It doesn't take much to get those contracts done. It is a very simple process. If you don't have them now, please get one. Because one of the things you need to consider is that when you don't have a contract, the law still speaks to what your relationship is. You are then under the common law doctrine of what the law in Ontario is going to tell you is that relationship. If you want to say what the relationship is, contracts. We need to contemplate disputes directly in them. So if that relationship were to break down, what are we going to do here? Are we going to court? Are we going to court in Ontario? Are we going to go to mediation? Are we agreeing to arbitration? There's various types of mediums that are much less costly than court, that are much faster than court. And you can agree to how those things work from the get-go. Another way to limit your liability. Please, please, please don't be using contracts you pull online. Or I often see people looking to enforce agreements that are American, that have nothing to do with our local law. Other things we see is, oh, a friend of mine paid a lawyer to get this done for her business. It's similar, or this experienced HR person has drafted it. Absolutely, you can bring in a base that has been created elsewhere, but before you implement it for your business, please, please, please have a lawyer look at it for you. What is right for one business and how they have brought it in is not necessarily what's going to be right on how you're going to be able to bring it in. There's nothing wrong with having a base to have a lawyer look at it. It's left drafting for us if it's viable. Sometimes that's a big if. However, you need a lawyer who's thinking about you and what your business is doing, how you're going to implement that contract. You know, a big thing we see is, you know, that longtime vendor is coming in. They're like, oh yeah, he's an independent contractor. Well, that's not necessarily always the case. We'll get to that when we talk about misclassifying employees. But the big takeaway is make sure that you're looking at your contracts, make sure you have those contracts, and make sure that you review and revise them on a predetermined basis, because if they're not actually reflecting your working reality, they may not be enforceable. Okay. So, funnily enough, when you're dealing with having a plan, know your actual terms and follow the plan. I cannot tell you how surprising it is to me when very, very sophisticated parties, multi-billion conglomerate clients of ours, will fail to follow their own agreements because they start following industry or their usual practice. They forget all of the work that they've done because the time of how it's going to dissolve is so far away from them that they forget. So if you are going to take the time and put in the effort to properly negotiate and finalize these contracts, keep a list, whether it's a contract summary or a procedure that's required for key things. So while it's still fresh in your mind, get that done, get your contract, get the key aspects that done, and put it somewhere that you know that you can keep it. When you're doing that while it's fresh in your mind, you're much less likely to omit those key steps at the material time. So that takes us to tip number 5. Don't assume that you know the law regarding employee contracts and terminations. It's not to be holding up lawyers' knowledge as something separate and above. It's just that there's a lot of maxims out there that are outdated, that are not legally enforceable, and that lead you to just unnecessary risk. And if your business is dependent on yourself and your team working well for you, you need to really consider employee contracts specifically, as well as what it says or doesn't say when you're dealing with terminations, okay? And this really applies whether you're bringing in 2 or 2,000 people. You need a thoughtful strategy, a documented process, and an airtight employment agreement. My bread and butter. It's my favorite thing is when I can tell people you are protected by the agreement that you have. Again, if you don't have one, you are subject to the common law. So you actually have obligations there, whether you have a contract or not. What you want to do is have a contract, even for small businesses, to ensure that you are protected in the event of terminations, or that to clarify also the rights and obligations for your employees. The best thing you can do is make sure, especially your longtime staff, that we all know what we're doing going into this and we can commit to this together. Contracts are certainly a floor, but meaning you can give people more than their contractual minimums, but your contractual, the way it's set, needs to be done in an enforceable way. So thinking about that, you can see in my big angry bold letters right there, it says there's no set equation. I often hear people tell me it's 1 month per year of service when we're letting someone go. No, that's not the case. On termination, you're dealing with a set of 3 different things, whether if a contract is there or not. You're dealing with the minimum amount of time prescribed by statute, the amount of time prescribed by contract, if there is one, and the common law doctrine of reasonable notice. Many employers have not thought about the common law aspect at all, because why would you? You don't need to. And many have not successfully contracted out of that either. So they're shocked when I tell them that that employee may be entitled to up to 2 years of full pay and benefits at the date of termination, even if they think they have good reason to terminate someone. So this is one thing. If you don't have employee contracts, this is a good thing to put on your list for proper legal hygiene assessments going forward, to make sure that you have that. It's particularly important if you have ongoing long-term staff, because the longer people are there, the more they might be entitled to. And while that's well and good, depending on what happens, if you have to terminate people as your business is starting to go through a difficult time, or et cetera, or things you can't plan for, knowing what the rights are for everyone is both fair and respectful to your employees, and gives you some peace of mind that you're limiting risk here. One of the things when we're talking about this, when we're talking about how much notice, I can't stress enough, because it's not an equation that you can just mathematically set. Judges don't even come up with the same amount of time. Often there will be a kind of a legal range that might be end up coming up, and it's not based on any one thing. It can consider things like an employee's age, their length of service, the availability of similar work, basic character of their actual job. Are they supervising people or not? So just because you have 2 employees doesn't mean their entitlements are going to be the same, even if they started at the same time. So these are things to consider that, you know, employment contracts done right can mitigate that financial risk outright for you. And again, it still gives you the opportunity to reward those that you want to reward above and beyond. The contract sets a floor. And again, contracts are not Instapots. Do not set it and forget it, please. If that person has stayed with you and their job titles have changed and their position has changed, we want to make sure they're reflecting the actual reality of that business. And you want to make sure it's enforceable. Again, this isn't something you just bring in all of a sudden. How you bring in employment contracts for existing staff is a nuanced matter and requires someone walking you through it. And that's just something to know, that it's available, and just because you didn't start out with them doesn't mean it's too late to get them. Okay. And just as a shout out, I want to make sure there is just a conversation about your reason to terminate someone versus legal cause. In Ontario, as an employer, you always have the right to terminate your employees you don't need a reason to do so, so long as their employment legal entitlements are provided. And again, those are decided based on statute and contract and common law, depending on what's applicable. However, one of the major things that we see is when people try and say, nope, you know, this person was a terrible employee. I've seen X, Y, and Z happen. I'm not giving them anything. I've caught them doing X, Y, and Z. And, you know, I'm going to fire them for cause because I have so much reason to do this. Just as a general rule, as much as we can, true cause where you are not having to pay them their statutory or common law entitlements is quite rare. And it's often reserved for very extreme circumstances. So you having a very good legal reason to fire someone does not necessarily mean that you're terminating them for cause. Legal cause is something separate and apart. So before you do so, which is often done in a knee-jerk reaction because something happened that people are upset about, before you do so, make sure you get some legal advice, pick up a phone and ask someone and just say, hey, this is what I'm thinking about doing. When my clients call me before they do this, we can make sure that that's structured in a way that there's a very simple process and release in that happens to protect the business. When I get called after the fact, often at that point, we're dealing with larger set of issues. So use the law to mitigate your risks by knowing that there is a difference between a reason and legal cause when it comes to termination. Okay. But again, as long as you have an employee contract too, in doing an employment contract, we walk our clients through that kind of stuff. So it may be worth investing a little ahead of time to avoid those costs down the road. This takes me to the dangers we talked about a little bit before about misclassifying employees. So you want to make sure you get it right from the beginning. When we're talking about misclassifying, we're talking about whether someone is a true employee, so therefore they have those that group of rights, or if they are an independent contractor. So, you know, if someone is coming in specifically to do something very specific and they're not limited to working for you and they sell to other people and et cetera, they may be an independent contractor. What I see most often as a mistake here is when parties just write an agreement that someone is an independent contractor, but they're not actually an independent contractor. It's important to know that the courts will look at what that person is actually doing. What is their role for you? How are they involved? Are they allowed to work for other people? Who's setting their schedule? Who's providing the resources for them to do their job? If that person is entirely dependent on you and is exclusive to you and is working for you, there may be a chance that even though you have a beautiful document that says independent contractor right off at the top, that a court will find that they're an employee. And if that person's been doing this for a long time, you may be exposed to quite significant damages in the event of that relationship breakdown or a termination. And you may not realize that. I have seen several independent contractor documents that are just simply not enforceable, or that are repeating every year. There's an annual provision every single year. That same guy is coming back and doing the same thing and only for us and all of these things. Rollover provisions are okay in certain contexts, but there can also be problematic. So don't assume just because you've been using the ones that you have there that they're actually an enforceable document. What you want to make sure is that they're classified correctly. And again, lawyers are not needed for every single one of these steps. However, if you're going to get your contracts up to date or just have someone look at what you existingly have, you want them to comment. This person, I think, is an independent contractor. Here's the document that says they do X, Y, and Z. And they'll ask you some questions. Often these things can be dealt with over the phone, and we can look at what you have via email, and you don't even need to come in. It can be a very simple process. So when people hear, oh great, yeah, another recommendation to get yet more lawyers involved, they don't realize, and we will get to, is that there's tiers of support that you can get that can be much more affordable than kind of the traditional relationship as well. But keep in mind that the reason this happens so much is the main benefit people have in calling someone an independent contractor is because those people are not covered by the employment statute, the Employment Standards Act, or ESA. Meaning it's cheaper for the employer to have independent contractors than it is an employee. In Ontario, if they're an independent contractor, the employer doesn't owe them anything in terms of overtime or vacation pay, and they have no obligation to pay for tax or EI or CPP contributions for them, or even WSIB toward that person. So, there's a huge draw for people to say, yeah, that's an independent contractor. We'll get them an independent contractor agreement. But again, with the developments in the law, the courts now look, and not just the courts, the Ministry of Labour and the Ontario Labour Boards will look more at what that person's really doing. So it is specifically contemplated that you can't simply name it in a mutual agreement by contract. It's more involved than that. So something to think about. Finally, as we get to our top three, just thinking about some basic components that often get left behind because small businesses, it's just so hard to get up and running and to put and get your profit margins up and to get the business to be viable and sustainable, that often the focus on things like HR is kind of in the back. We'll get it done, we'll do what we can, but we don't have an HR department and we don't have X and Y resource. Even when you have very limited means, just consider some basic avenues. When we talk about hire the right people, sure, that's an obvious given. No one's hiring someone that they think is going to be terrible. But when you do hire the right people, you're going to avoid having to discharge bad hires or having discipline issues or customer complaints. So starting that with the right recruitment resources and the right paperwork can be really helpful. Using a legally compliant application form and a precise position description is extremely helpful. If you find someone's acting outside of that scope, that becomes a different question when there is a set scope there. Often a mistake I see is that people don't have position descriptions like, oh, you're a cashier. Cashier at your business versus mine might look very different. And so these are things that you actually need to set that expectation, set what you're expecting someone to do. If you expect them to be a good employee for you, put out on paper what you're expecting to do for them. Set that expectation clearly from the get-go, and it makes addressing issues that are outside of that much easier. Think about also using lawful and effective interviewing techniques. Sometimes there's questions that just should not come up. You're not asking people about, their family status or things like this. Even if you're very interested, even if that person is sitting in front of you interviewing pregnant, you need to be conscious of the language that you're using. Being a small business isn't going to save you from being told that you went too far or were inappropriate in those kind of application processes. So be cognizant of the language that you're using. And then seek out real feedback on a regular basis. Often people will say, we'll have an annual performance review. Well, there's nothing wrong with an annual performance review, but consider if, especially in a smaller group, if you can have something a little bit more often to encourage communication being open and back and forth, be open to receiving feedback. What can you do better? Because often you'll find out the things that become litigation issues down the line. You'll find out, usually employees will bring these kind of issues up to employers first. Where they fall on deaf ears and they fester and escalate, that's when we see litigation. But having a culture where there is a regular time for check-in, where they can bring up issues without fear of retaliation. If it's just you and them, that's going to be a trickier situation. But fostering that communication pathway and making sure that people are feeling comfortable to speak to you, that becomes a really crucial part. You don't need an HR staff for that, but you need to consider that HR role. And again, if they can identify stresses or sore points for you early, then we can avoid needing to call lawyers at all. So with that, if an employee does bring up a complaint or a customer brings up a complaint about this kind of thing, address it right away. Take it seriously and see what happens. You may find out, yeah, you know what, this is a one-time issue. It's not something that we need to be concerned about at this time. But it may also be that there's a simple solution that you can put in place now to prohibit that issue from going forward. It sounds really trite to say with everything that's going on. It's like, yeah, okay, I'm going to take my people seriously. But actually giving real space to that and just kind of accepting it as valid, rather than what we often tend to see is defensive. No, that's not a big deal. And it's a minimalistic approach. That does not de-escalate anything. If you've ever been told to calm down by someone who you're angry, I'm sure you felt real calm afterwards. Having someone hear you and say, let me take this away, and we'll get back to you. Even if it's a small please, let me take this away, is a helpful point for you to avoid knee-jerk reactions, for them to know that you've heard them and that you've considered what's going on, and that heard part that you've listened is crucial. What I also appreciate when my clients call me is when you have said that, like, I've heard you, let me take that away. I'd appreciate if you can send me an email just to, make sure I've captured it right so I can think about it, and I'll get back to you. That's where they're getting that person to do the documentation for them. They're making sure that they've clarified the understanding, and they're omitting a knee-jerk reaction of, I can't believe you would say that. I can't believe this. There's a standard response that they know. Yes, I heard you, it's documented, and then you've given yourself a hot second to actually contemplate what you actually want to do about it, and it's not simply a reaction to negative information. That's a crucial way to de-escalate issues from the get-go. And finally, when you're considering about this, think about having workplace policies. Some you're obligated to have, like a workplace violence or harassment policy. The Health and Safety Acts are requiring you to have those, but making sure they're communicated to your employees. Make sure that it's very simple and it's aware. Sometimes having just an employee handbook that you regularly update annually is an easy fix. You may need to have one-time memos if something happens that come up to kind of support them, but making sure you're communicating with your people about the practical realities they're seeing and what policies you have in place to do it. These don't have to be huge documents. You don't need to see giant binders worth of things. Digestible, practical steps are very helpful so that employees know what to do, or customers can know what to expect. It's helpful to have these down and ahead of time. And if you get an issue that's not handled in a policy, that's a great time to figure out how we can avoid this. Do we need to update that document? It's surprising how many claims can be shut down when we can see that the employer has taken all reasonable steps to do what they can here, and has always done so. And that practice of good legal hygiene, it really shines through to save you those costs. And finally, just, in doing that, even if you only have a couple staff, just consider some of the realities of the multi-generational workforces. I know we always hear about millennials, but millennials only make up 35% of the workforce. It's important to consider that you've got baby boomers and Gen Xers and Gen Zers when developing that kind of HR style. And all that means to say is consider the people, who they actually are. Having a one-size-fits-all, I respond to things like this, isn't great. Taking the time, even if you don't have an HR department that you can support in doing this, or you don't have an HR person and it's just you, taking the time to actually hear what people are saying to you and reflect on it, even if you disagree, even if nothing's going to change, even if that's not the case, taking that time and doing that is invaluable. You will hear things that you didn't otherwise expect to hear if you allow yourself to be someone who people can come to. And in that piece, without it being a bleeding heart scenario, you can practically address it and you can take real steps to be pragmatic about it or approach. They feel heard, and you also get the opportunity to limit the risk that you might be exposing your business to. and that becomes a crucial consideration. So that takes us to number 2. Be prepared that no matter what you do, no matter how much you prevent, no matter how much your documents are well vetted, that some disputes are going to escalate. Some are just the nature that that's what they are. Some also should escalate. Some of them you need to stand your ground and you need to send someone in to advocate fiercely on your behalf to say, hey, like this isn't okay. What I recommend when you have that kind of goes off a little bit from tip 3. Listen first. Very rarely does this as a claim happen and shock you. Are you just immediately served with a statement of claim, or that you feel the need to just run into a statement of claim? There's often a dispute at the heart of this. Typically, it will be brought forward. Even if you get a demand letter from counsel that you disagree with and you're like, oh my God, who is this person? Listen first and document it. When did you get that? When did they first talk to you about it? What did we take away from this kind of stuff? You'll see my and document here on the first 2. Listen, but document that you listened. Quick emails to yourself or quick emails to, to keep this there. Really easy way to do it if you're a fast typist. If not, write it down, tuck it in an employment file. That's not a problem. But really listen first, because often the issue is, okay, I don't agree with what you're saying, but what is the heart of the issue here? That is a lot about what we do in pre-litigation negotiation. I understand you're asking for the sun and the moon and the stars, but what is this? What is this really about? What is the interest that we're dealing with? If you can figure that out at the beginning and document that you're making good attempts to do so, you will often find that you don't need to go anywhere near courts and lawyers. You can, if you do listen first, negotiating becomes much easier. Just because someone said, I'm going to sue you, I'm going to do this, and you're like, there's often a style of negotiation that is appropriate to each situation. Sometimes you need to shut it down. You need to shut down the conversation and that's there. But I find rarely that's the case. Typically, people watch far too much Suits and they're very excited about legal cop shows who they want to put someone up against the wall and tell them how it's going to be. I've never once seen that work. I have seen that escalate extremely and cost people literally millions of dollars. Nobody wants to be intimidated. They want to be heard. And in doing that, if you can negotiate in a common pragmatic way, great. Do some direct negotiation. Say like, what are we talking about here? That's not a reasonable position. Here's where I'm coming from. What's going on? If that person's belligerent and not going to help, don't do that. If you can't stay calm, if you can't distance yourself enough from it to keep a calm and reasoned approach, you represent your business, then you shouldn't be the one negotiating that either. But don't be afraid to negotiate. That's often where I hear people, they said, I got this letter and I can't believe it. And they came to me with this email and this allegation is crazy. Sometimes it helps, pick up the phone and say, listen, like, I just want to understand where you're coming from and let them talk to you and hear what they're having to say. A, you're going to help the lawyer have a better, if you do decide to get counsel, have a better idea what's going on. And B, you're taking the reasonable step of trying to hear them out. Whether you agree with them or not, whether you're going to shut them down or not, whether we're going to fiercely advocate for them in court, which is a whole aspect of what we do here. Having that opportunity to hear them out can really minimize and de-escalate situations. We may find out that you were sent this angry letter of the sun and moon, the stars, but the issue is one thing. And we may be able to find creative ways to solve that without going to court, whether that's starting out mediation and figuring out, okay, let's get past this sticking point. We both know we want to resolve this, but we're at an impasse and it's escalating because we're mad about this spot. Let's talk about mediation. It can be confidential. It's consensual. Everybody has to go if they want to go. Nobody's obligated to attend. It can be much cheaper. It can be done much quicker. That's often something that people don't realize is an option to do outside of the litigation process, outside of the mandatory mediation that happens way down the line. You can make those steps if you're, can deal with things other than this particular hot point. And the other side is that sometimes you just need to be able to go to court. Sometimes you need a decision maker to say yes or no and move it forward. And the more reasonable you can show that you are, the better that conversation is going to go. And that's when you need to consider engaging counsel to invoke privilege. Solicitor-client privilege is something we take extremely seriously. It is part of our requirements. It is something that you can use as a strategy when you want to enclose the discussions you're having about this issue or this individual with privilege. As soon as litigation is contemplated, then privilege is going to be invoked for litigation privilege. That's separate. Litigation privilege is a different thing, but solicitor-client privilege starts right away. So if you want to have those conversations, or just a heads up to have those discussions, know that you can engage counsel straight up to invoke privilege. That doesn't mean that you have to go to court just because you've engaged counsel. And that leads me to my final point. You do not have to do this alone. There's strategic defenses that you can employ and tiers of legal support, and this is a wildly underutilized concept. You don't have to engage counsel specifically to go to court. You don't have to decide that you want to sue someone to send a counsel-based demand letter. You can call and say, listen, I need to retain someone so that when I have issues, I know that you know my business, I know that you know how to deal with this, and I know that I feel comfortable with you, that you understand what my goals are for my business. Some things that we see that people are often surprised we provide is I kind of think about it as, when you have a cell phone plan, there's packages you can involve in or take the minimum package, things like this. Often people are thinking about a retainer means I have to use this lawyer for everything under the sun and I have to go to court. That's just simply not the case. If you want to have an initial consultation to check your legal hygiene and then have that person keep a file open for you for general employment matters or general business related issues that come up for you, just so you have someone you can pick up the phone and call to, those can all be things that are negotiated ahead of time. Limited scope retainers are exactly for that. I'll give you an example of some of the things that I let people know that we do. Ghostwriting. I've often been retained for people to help them de-escalate something without anyone being aware a lawyer is involved, which means they're dealing with maybe a harassment complaint or a termination issue or disgruntled staff or a business acquisition deal has gone awry. And they want to be able to start documenting that they're taking good and reasonable steps, but they don't want to have to pay a lawyer to be involved. They're worried about bringing in a lawyer that will just physically escalate the situation at all. So we ghostwrite some of their emails. We ghostwrite some of their letters for them and say, here's the legal pieces you need. Put this in your own words, but this will help if it does fail and you go to court, then at least you're showing that, you started doing good steps. You've put them on the right notice. You put them on the right frame of mind. You've been reasonable, calm, neutral, even when you're upset, even when you're angry, that you represent your business and that you've been calm and have taken good steps. And if you haven't, that you've backtracked from that and reset when you need to. We've done things where, someone will have the heavy lifting of drafting done by an HR friend or an HR department they have, or some sort of consultant where they just want us to check it out. Can you just give us some comments? I don't want you to fix it or draft it. I want you to give us some comments, and they'll go back and make changes and we'll come back. Sure, that's often a cheaper way to do it too. Reviewing existing contracts, finding a time to say, okay, this is going to be my legal hygiene appointment. I want to see, is what I have okay? Am I actually protected on this? Does this contract mean anything? What I see often is someone will get a contract that they had reviewed for new employees and then try and give it to existing employees. That's not an enforceable thing to do. There's a manner in which it has to be brought in. So, when you want to just have someone take a look, what I recommend though is when you're doing this, discuss your pre-litigation negotiation style. Are you someone who I don't want to have to deal with this? If this comes up, I just want to know that I can send it to you and I don't have to deal with it. Or I just want to know that you're on the phone so that I don't get a lawyer because I'm scared and feel I need a lawyer, that someone can walk me through, okay, what am I going to do today? How am I going to handle this to avoid the claim in the first place? I personally like to write lawyers out of it as much as possible, because I think most people, particularly small business owners, are very intelligent, very articulate, and very capable in dealing with these issues. Often law support is only needed to guide and consult on areas you wouldn't have to worry about or wouldn't necessarily know about. And at that point, if you don't need us, we should be the first ones telling you that. This is likely something a free consultation over here might be better, or letting them know, give them a little bit more time for that. I can see what you're saying. Try this. No matter what, though, if you are engaging any sort of tier of legal support, whether it's the full litigation, let's go forward, or just a basic initial, hey, I just need to know I have a teammate that I can call who knows what I'm talking about here. Ensure that there's someone in good standing with the Law Society of Ontario. I see every now and again terms like legal practitioner or other kind of things. If you're going to go get legal advice, make sure that that person is registered with the Law Society and in good standing. And just keep in mind, You know, you don't need to have a fierce advocate and to have someone who can put forth the strongest and best argument for you is not the same as having some sort of ridiculous theoretical pit bull who's just going to scream and yell at everybody and put them down on the wall. That doesn't work. That adds way more cost, and that is just the wildly inappropriate way. And fortunately, the culture and laws, people have moved away from that for the large part. So in thinking about who you're going to hire, do you need the most expensive lawyer? Do you need maybe a junior who's being supervised? Think about what your needs are and not coming from a fear-based response. Often, you know, you might only need a basic consult. While it won't feel basic to you, you might not actually need the $400 an hour partner, the $700 an hour partner, and maybe you don't even need an hourly piece. Maybe you just need to come in for a meeting and agree on what that fee is going to be to just run it by someone and show them things in person. Get a feel for it. You know, if a lawyer is going to be a part of your team, vet them like you would with the rest of your staff. Make sure it's someone that you feel who matches with your business plan and your idea of law, so that you know that in a pinch that you can trust their judgment. And in doing that, focus on people who are going to try and get you to help avoid litigation. The last thing, the amount of expenses you're going to pay for legal fees, ideally you want people who are going to focus on resolving your complaint, resolving the dispute with the best possible outcome, and keeping litigation for an absolute last resort. So that is it. I'm sorry for all of the photos that are right there. But again, my name's Kate Agyemang. I do employment law, health law, civil lit. As a firm here, we do a lot of insurance defense, and we are a full service firm. We've got wonderful solicitors over in our West End office and some here downtown as well. But hopefully, really, if you take nothing else away from today, I just want you to know that you can avoid litigation. You can reduce significantly how much you're dealing with. And really what it takes is, you know, any sort of litigation is going to take away from your productive business endeavors. And our job is to avoid that for you. Our job is to help be on your team and make sure your business is first and not, you know, some secondary side piece to our litigation dreams. Okay, that's not what we're here for. So make sure that you are finding the help that you need when you need it, and only the kind of help and level of help that you need. If you do need help trying to find any ticking time bombs that you might be handling over, feel free to give us a call at any time, and we'll figure out how to help safeguard your business in a way that makes sense for you and on a timeline that makes sense for you. Thank you.
Thanks, Kate. Keith Gallup here, sitting beside Kate, taking in all these points. Thank you very much for taking us through all that. A lot of very useful information to think through. If people do have questions, by all means, send them in right now. You should be able to use the control panel to submit those. And also just a reminder that the handouts are also in that control panel, the slides, so you can download those. And if you have any trouble with that, just drop us an email and we can follow up with by email, sending you a copy of those. This has been part of our series of webinars for small and growing businesses. The earlier first three are all available on the Kelli Santini website or YouTube channel that address things like hiring your first employee. The first one dealing, you know, the review of the various advantages and pros and cons of different business structures. Taking out your first commercial lease, funding. So lots of useful information there for small and growing businesses. Kate, a couple of questions. You mentioned hiring the right people as a key part of it. Can you start out with a contract?
Absolutely.
You know, and actually just, you know, try people out, make sure they're okay before you take them on as a full-time employee?
Yeah, absolutely. You know, we still have, you know, when you're having people come in and they're going to be probationary things are absolutely relevant. What you want to be careful of is how long you think probation might be. I've seen actually recently a few that had probation extended for 6 months or extended when someone had issues. Probation really is going to need to be limited to 3 months to give you a dry run. But that doesn't mean that you have to go right into a permanent employee aspect either. If you still want to vet them for the next year, give them a contract, you know, where it's a fixed term contract rather than permanency. You know, permanency legally, we talked about that as an indefinite term. But you can absolutely always hire someone and have a normal 3-month probation. Feel free to move that to a fixed term contract if you want to do it that way. There's ways of doing it. It depends on how your document is structured from the beginning to make sure that you're setting out a clear expectation. Often in that case, if you're nervous or you're in a business with high turnover, what I often see for people is that they don't offer that indefinite term, that permanency until after someone's been there a year. That way you have kind of the full 3 months probation, they're committing to a fixed term. The only caveat to that you need to think about between fixed terms and indefinite is the kind of people that you're going to get. People want the security and potential benefits that come with being in a permanency. So depending on what your role is, you might want to rely on that 3 months, or you may not to. But when you realize that you can also terminate people no matter what, we can speak to that in the fixed term contract to mean that you can let someone go in that first year and you'll know what that risk is, so that you're not feeling just because they're on a permanent contract that you're suddenly stuck with someone that maybe you're unhappy with.
Okay, and we've just hit the top of the hour, so let's just do one more question, then let everyone get on with their day. You mentioned the importance of actually having properly executed, signed and dated contracts. What is the process? What do you have to see? And there may be misconceptions as to what is actually a properly executed contract.
It sounds really trite to say, but genuinely you really want to see an actual signature and an actual date next to that signature and witnesses if necessary. I cannot tell you how many I've seen where it's only one party who signed. They didn't bother to collect that other piece from the vendor or from that business service provider or that employee. So what I want to see is that it's dated. I can tell you when this happened. I can tell you who signed it. I can tell you that the person who's signing it on behalf of the company had the authority to do that. Is it a general manager? Is it your CEO who's doing it? In the restaurant industry, that can become a complicated decision. So I want to make sure that that agreement is not being given out just to vet what a job could look like. It's being given and properly reviewed together because an agreement is being formed. So when we see that piece, having it really properly documented and then there in an employee file, it becomes crucial. Please don't send me things that where you just have, there's no signatures and it's, no, I gave him to this, he signed it, I don't have the signed copy. That becomes very tricky.
All right. Thank you very much, Kate. And thank you, of course, everyone for tuning in this afternoon. I hope you enjoyed it. By all means, follow up with any questions if they occur to you. You have Kate's details there, and enjoy the rest of your day.
You're free. Thanks.